it changed the entire format for how it was going to handle the reopening procedure. And it called this the blueprint for a safer economy. And so instead of the previous factors, it simplified it to having two. One, the daily new cases per 100,000, and for counties that don't have 100,000 residents is by scale, and then also the percentage of positive tests. Now, the state is continuing to adapt and adjust this and tinker with this blueprint. For example, on October 6th, they added something called the health equity metric, and it intends to eliminate disparities. Sometimes with bigger counties, there are areas that are doing very well at COVID protection, and then there are areas that are not. And so the health equity metric seeks to normalize and standardize the process by not just taking into account the whole of the county, but also specifically across the board. Counties are now classified into 4 different ones. There's the widespread, substantial, moderate, and minimal. Widespread counties involve more than 7 new cases per 100,000 residents and a greater than 8% positivity rate. Substantial, you're looking at between 4 to 7 new cases per 100,000, 5 to 8% positivity, and 5.3 to 8% on that health equity metric. Moderate, as you can see, 1 to 3.9 new cases, 2 to 4.9% positivity, 2.2 to 5.2% health equity metric, and then minimal is underneath all of those thresholds. Orange County currently is in the substantial category, where I am at in Los Angeles. We are in the widespread. And so this is, at least for now, the metrics that as the state continues or in some industries begins to reopen, these are the metrics that we will want to be paying attention to determine what various forms of reopening can occur. Next slide, please. And to assist with the reopening process, the state of California's Department of Public Health, as well as its Department of Industrial Relations, has released 2 major resources for employers to help them determine how they can reopen safely. First, you have the COVID-19 Employer Playbook for a Safe Reopening. That is the Department of Public Health resource. But then there's also some Safe Reopening Frequently Asked Questions for workers and employers, and that's issued by the DIR. We're going to start with the Employer Playbook, and then we're going to move into the DIR's FAQs, just some brief points on that. All right, next slide, please. All right, so the most recent revisions of the COVID-19 Employer Playbook occurred on July 24th, 2020. So this was before the blueprint became the new mechanism and standard, but a lot of these same guidelines that have been put forth in the playbook still apply to businesses as they're reopening. It's interesting that it attacks it from both the employer standpoint and the employee standpoint, outlining the responsibilities that both groups have to prevent and mitigate the spread of COVID-19. There's a lot of information in here. We're not going to cover all of it in this presentation. We have the link to this resource at the end of the slideshow, but we would encourage you to look through it. It's 34 pages. Lots of it is new information, but we're going to touch on the highlights here. Next slide, please. All right, so it begins. One of the key things it has for a business that is emerging with this new blueprint, a lot of industries and businesses that were not allowed to reopen got the green light to do so. And as Orange County is now in the substantial, and hopefully as it moves into the moderate and into the minimal categories, more businesses can be reopening for the first time or expand their reopening to allow for greater amounts of people to enter the establishments. And so the playbook has a before reopening checklist, and I'm just going to briefly move through all these points. First, most especially, you're going to hear from us throughout this presentation, one of the most important things that can happen is for the business to perform a detailed risk assessment and create a work-specific COVID-19 prevention plan. The state of California has a lot of industry-specific resources, which are a great starting point, but no 2 businesses are created the same. The layouts of the company are different. The interactions with customers and with one another are also different. And so the playbook encourages a work-specific prevention plan. It needs to have a plan. And not only does it need to have a plan, it needs to train workers on that plan, teach them how to limit the spread, Tell them about the individual control measures and screenings. Are there disinfection protocols in place? What are the physical distancing guidelines that are in place? What face covering requirements are in place? And it links to a couple of the resources from the Department of Public Health for face coverings, as well as the industry-specific guidelines, which can serve as a template, as a format, but these plans should be work-specific. Next slide, please. All right, and one of the other key components of this plan is to designate a workplace infection prevention coordinator. Rather than having a numerous amount of individuals tasked with the responsibility of making sure all the COVID procedures are in place, designated a single coordinator will help streamline the process and allow these companies to really coordinate effectively. That person will be in charge of staying up to date on sick leave policies. There have been some new laws in place that we will touch on later that affect employers of various sizes regarding new supplemental sick leave procedures. The workplace infection prevention coordinator should be the one coordinating and instructing employees to stay home, report their COVID-19 issues to the company. And this workplace infection prevention coordinator has the very important job of coordinating with the local health director, or as you'll see through the slides, we abbreviate to LHD. And what the LHD is going to want to do is, one, they're going to want to receive information about known and or suspected outbreaks and develop tracking mechanisms therein. And we'll touch more on that on the next slide. So first, before we talk about specific things to talk about with the LHD, one thing that businesses should be in mind of is that there's two major jurisdictions that they should be concerned with. First, the worker's local health director. Where the worker lives, let's say the worker lives in Los Angeles County. Los Angeles County may have different reporting procedures. It may have different requirements, restrictions than Orange County. The workplace may be in a different county as the worker, and so it's important to consider both and to be coordinating and communicating with both jurisdictions' local health directors to make sure that there is coverage across the state. The last thing that the state or the businesses or anybody wants to do is to move back up in a category, regress rather than progress down to moderate, minimal. Or in Los Angeles case, we want to move down to just the substantial to begin with. Local health directors, depending on the jurisdiction, may want different information about how frequently they want updates. Some may be more hands-on, some may be more hands-off. Some might want information by the hour, perhaps daily updates. The security of information is also important and may vary by jurisdiction, and also just the transparency. There are some information that the playbook specifically identifies as local health directors wanting to know, but depending on the jurisdiction, that local health director may want to know more. Job descriptions, locations, work schedules, residence information, other details along those lines. Next slide, please. So this workplace prevention coordinator will be coordinating with the local health director about testing strategies. Two of the most important ones that come to mind are tracing mechanisms, determining where the virus started and potential close contacts or other people that might be infected, and also determining, although no business wants to have this happen, whether the business, because of the potential outbreak that's involved, it would be best served to be temporarily closed. And that's why coordinating with the local health director to make sure that they and the business are at the forefront of making the decisions, that they are understanding all the information, and they can come to as much of a coordinated response to prevent the spread. And as I mentioned on the previous slide, some information that the local health director is certainly going to want: job titles, work areas, close contacts. We're going to define that term a little later in the presentation. Dates of when the symptoms first began. That's very important for tracking the incubation period. We don't just base the infection on the day that the symptoms first began developing, but 48 hours prior. And shifts worked while infectious, not just when the symptoms began, but for that 48-hour period before. That helps to develop the tracing mechanisms that the local health director will want to implement. Next slide, please. So this is where we're going to discuss close contacts. The local health director is going to want to coordinate interviews with potential workers that might also be infected. And the playbook and related guidance provides a very specific definition of a close contact. These close contacts should self-quarantine, self-monitor symptoms, and they should be tested to determine whether they themselves have been affected or not. And a close contact can be either one of two different groups. Either A, you're spending 15 minutes or more within 6 feet of an infected individual during their infectious period, which includes at a minimum, as I said before, the 48 hours before the individual develops symptoms. Notably, this particular prong applies even if the individual is masked. So if someone, let's say a worker has an infected person in their house and they have been their primary caretaker, they have been treating them for their illness, they have been in the room for an hour within 6 feet of them, monitoring their symptoms, even if they're wearing a mask, they are considered a close contact. The other way to become a close contact is if someone has had unprotected, not wearing masks, contact with someone who is infected, their bodily fluids. They're coughed on, they're sneezed on, something like that. And so there are two different ways that the local health director and businesses should be aware of how to define the close contact when they're conducting these interviews, and for workers to help understand themselves where they are at on the process as well. Next slide, please. And so some of the keys to communicating with employees and determining whether interviews need to take place and just communicating about potential outbreaks, they need to know, businesses need to notify everyone that is potentially exposed, but also keep things confidential. You want to notify everyone, but you can't say John Smith or Greg Lewis had COVID, everyone who is with them be warned. You want to have a more generalized statement where there has been an individual who has had a suspected outbreak. The playbook has some language specifically for addressing a communication to the workers that both protects confidentiality and sufficiently informs them to adapt to your purposes. You will also want to collaborate with the employees, determine who their healthcare providers are, determine who their close contacts are, and identify and provide information to them. For employees whose shifts are interrupted, let's say that there is an outbreak identified, employees are sent home to prevent further spread. Help them understand what happens with the interrupted shifts. We'll touch on some of the potential claims that could arise based on interrupted shifts, reporting time implications being one of them, but also for individuals who are unionized, bring in the representative organizations or the point personnel if they are a contracted worker. Instruct employees to follow the guidance. Essentially, throughout all of this, the more hands that are in the know, the better. You don't want to be hiding information from the employees. You don't want to be hiding information from the unions. You don't want to be hiding information from the local health director. More communication is key, but the communication should be confidential. Next slide, please.
Hey, and before we go to that next slide, just to follow on Greg's point, this is Spencer. That is one of the things that early on in the pandemic, we saw a lot of employers just not really understanding, and in terms of the communication and being open about what happened, that there was a positive test, etc. And now looking back, we're seeing how problematic that can be. So that's, I would say, one of the biggest lessons for employers from the first few months of COVID-19.
Thank you, Spencer. And we'll be touching on that a little bit more. The playbook for workers who are infected or have potentially been exposed, the playbook identifies 6 different categories of workers: symptomatic and asymptomatic being one general breakdown, but also positive, negative, and untested. And those make up the 6 different categories. We're going to go through each of them and how an employee who falls into one of these categories should respond themselves. Next slide. So we're going to start off with the symptomatic positive individuals. These are individuals who have symptoms and have been laboratory confirmed to have COVID-19. Self-explanatory, symptomatic individual, positive test. And in order for this individual to return to work, they have to satisfy all 3 prongs of what I'm going to refer to as the 24I-10 test. And what that means is they have to go 24 hours since the last fever without any fever-reducing medications. There has to be improvement in those symptoms, the cough going away, some of the other sorts of symptoms that arise, shortness of breath becoming better. They're able to breathe much, there's improvement in their breathing. And also 10 days have passed since the first symptoms appeared. Remember that 48-hour window is important because we track that back. So generally speaking, there's a 14-day quarantine, 10 days, symptoms appear, we backdate the 2, so that's 48, we're about 12 days. And so that is how the California Department of Health requires for an individual to return to work, satisfy the 24I-10 test. Now, one of the things that we are frequently asked is, well, what if the individual returns with just a negative test? Is that sufficient? Do they have to satisfy the 24I-10 test? And what we recommend is still yes, because we don't know at what point they receive a negative test, whether 10 days have passed. They could still have a negative test, but potentially be contagious. Or perhaps that test was a false negative and they're still positive. And so, although testing at the work site is certainly important for individuals who are symptomatic positive, we will also recommend them to satisfy the 24I-10 test in addition to going through on-site testing before returning to work as well. Combination of the both, but not exclusively a negative test. Next slide, please. So then you have the asymptomatic positives. And this has been the category that has concerned most businesses, politicians, general members of the public, someone who is positive but doesn't know it because they're not showing any symptoms. So for these individuals, the return to work criteria is a little bit different because the 24I-10 test doesn't work as well because they haven't had any symptoms. So their return to work is 10 days have passed since the first positive COVID-19 test. If they do develop symptoms, then from that day, then they have to satisfy the 24I-10 test. So the day they first develop symptoms, that's when the 24I-10 test kicks in. Otherwise, they just have to have 10 days elapse before returning to work. Next slide, please. Symptomatic negative, someone who has a cough but is negative for COVID-19. This is especially important as we enter flu season, as the weather becomes a little bit more chilly. We want to make sure that employees don't just have a cold, but because of the risk of a false negative while this pandemic is going around, the playbook still recommends them to follow the 24I-10 test, just in case there's a false negative, just in case due to the delayed incubation period of the virus, they would test positive later rather than earlier, then we would recommend, and the playbook recommends, following the 24I-10 test for these individuals. Next slide, please. Asymptomatic negative individuals. And this is going to seem a little bit different. Workers who never had symptoms but were tested due to close contact with a laboratory confirmed case patient and were negative. So individuals who were close to a confirmed patient for 15 minutes or more, or have been sneezed on, coughed on, somehow come in contact with bodily fluids of an infected person. For these individuals, they are to self-quarantine for 14 days. This may seem a little bit counterintuitive because for the person who is positive and symptomatic, 24I-10 test, 10 days, this person's 14. But remember the 48-hour build-in period for the symptomatic patients, and for the positive, we date them back further because the virus sometimes will just sit within the person. It will incubate and test positive later on down the road. So for these individuals, this is why the Department of Public Health recommends a 14-day quarantine to allow some of that time for incubation to manifest, to make sure that people are not asymptomatic positive or develop symptoms on day 9 or day 10 or day 12. So self-quarantining for 14 days. Now, this is why communication with the local health director is important, because for these individuals, they may consider allowing an earlier return to work if there are 3 conditions satisfied. 3, not 4. First, if they are in a critical infrastructure industry, and those have certain definitions. Second, if essential operations are compromised by the worker's quarantine. The work that worker does is so important that they need to be there, and there is no alternate staff members who can perform that role. The local health director may then move to, as we'll see on the next slide, additional questions to determine whether that 14-day window can be lessened to perhaps 10 days, or depending on the local health director's advice, even shorter. Next slide, please. So if, again, putting it there, just so you have the whole early return to work test, if that worker is part of a critical infrastructure industry, if their essential operations are compromised by their quarantine, and there are no alternative staff that can perform the worker's role, the local health director, if all 3 of those categories are satisfied, will then consider whether an early return to work is appropriate. And they will determine that if perhaps if the worker is able to wear a face covering and is able to easily social distance, if they can self-monitor their symptoms, if the facility has a plan, pre-screening procedures, best practices implemented, and the worker is able to comply with those prevention procedures as well. The worker is not going to be allowed to come back to work if they can't wear a face mask, if they are not easily able to social distance because of the concerns about incubated spread. And this is, again, to stress the importance of having a plan, because that's one of the things that the local health director is going to consider. Does this facility, individualized, not industry specific, does this individualized business have a plan for making sure that COVID is not spreading in the workplace? Next slide, please. So the final 2 groups of categories, we have the symptomatic untested individuals. These are workers who had symptoms, but were not tested. Return to work criteria, test the worker. That is extremely important. You can have on-site testing. California Department of Public Health guidance allows for the mandatory testing of individuals. And so if testing is not possible for that symptomatic untested person, follow the 24I10 test. If they don't want to take a test, but they're symptomatic, 24I10. But having a test will help to determine whether that is in fact the appropriate category. But because they are showing symptoms, regardless of whether they're symptomatic positive or symptomatic negative, they will be required to follow the 24I10 test. Next slide, please. Now, for the asymptomatic untested individuals, there are 2 different variations here. First, there are the workers who have close contact to someone who is positive and they don't have symptoms. Or these are workers who just flat out refuse or can't take a test after being a close contact. So for these individuals, you'll see that these are very similar to the asymptomatic negatives. Self-quarantine for 14 days. Want to make sure that there's no incubation, want to make sure that there's no potential spread. Testing is highly recommended because depending on what the test result is, they may have to follow the I-2410 test, or they may be eligible for return to work procedures. So that's why testing is highly recommended for these individuals. If symptoms do develop, as with the symptomatic anybody, 24I10 test is the measure to use. Next slide, please. So other general topics that are in the playbook, cleaning guide. What are some best practices for cleaning the workplace? For shared equipment, for personalized equipment, for cleaning surfaces. There's also topics about recording and reporting cases of COVID-19. Paid sick leave benefits, those should be updated based on the most recent guidance that has come out. disability insurance benefits, how to coordinate and inform workers about these benefits, recommendations for workers to protect themselves while they're at work, as well as various appendices of resources. We have some of them linked at the very end of our presentation, but there are other resources that are available in the playbook. Next slide, please. All right, now to the Department of Industrial Resources Safe Reopening Guidance. We're going to move through these really quickly. Next slide, please. So for the DIR, it really instructs employers about things they can do and things they can't do. So employers can't charge employees for employer-provided face masks. This goes back to the principles that the employee should be reimbursed or not have to pay for necessary business expenditures that the company requires, which is the rationale behind this rule. Additionally, reporting time pay, being paid for all time worked is an important consideration for this next slide, next bullet point about compensating workers for time spent on on-site temperature or medical checks. They are technically working. They're on the work site. They are taking a temperature to be able to work. And so reporting time pay obligations will generally apply. Now, these compensation considerations are case specific, can't say that word, for at-home medical checks, depending on the amount of control the employer has over the check. Additionally, for cell phone reimbursement, some medical tests involve filling out questionnaires on the phone. That's a case specific as to whether an employer will have to reimburse for that as well. Next slide, please. So next, employers can require workers to return to the work site even if they are able to work from home. That was an important question that employers were asking, and this was the answer given. Additionally, very important, there have been a lot of documents that have been prepared in order for employees to return to the work site after they are required to do so, or if they are required to do so. In those documents, employers cannot require workers to waive labor code rights as a condition of returning to work. I'm going to say it again because it's extremely important. Employers cannot require workers to waive labor code rights as a condition of returning to work. And we're going to touch on workers' compensation a little bit later because there's a new law in place that's very important. But basically, an employer cannot say, by returning to work, you can't hold us liable for having an unsafe workplace or for you contracting COVID while you're on the job. They cannot do that. And so make sure that in your documents that you are preparing or utilizing K&L Gates or another law firm to help prepare those documents, that those types of clauses are not present in those documents. And I think that is all the COVID related materials that I have. I think we're going to kick it over to Ashley, and she's going to talk about some of the new employment laws, some of which directly deal with COVID.
Yes, and before we do that, we want to touch upon COVID-related claims that employers are facing this year. Next slide, please. We are seeing a general rise in claims for an employer's failure to provide a safe work environment. As you may be aware, employers are required by law to maintain a safe environment for their employees to work in, and that includes providing proper protections against infectious diseases like COVID. So potential basis of liability for either gross recklessness or negligence against employers include failure to properly screen employees for COVID, failure to protect employees from other symptomatic persons, as Greg discussed, just generally failure to cleanse and sanitize the workplace, failure to provide PPE, social distancing policy, et cetera. And it will discuss a new California law that actually mandates a policy to be implemented and given out to employees if there is an infection in place. Next slide, please. There are also discrimination claims based either in age or disability. Also, even pregnant workers could bring these claims. For instance, a 70-year-old could allege he was denied a work from home accommodation due to his medical condition and age, and that would be a basis for such claim. Harassment of Asian workers, just calling it the China virus, etc. Failure to grant requested leaves of absence under FFCRA, FMLA, CFRA, which are all protected leaves as well. And as well as for potential failure to accommodate employees with medical conditions such as asthma for workplace modifications while they're at work. Next slide, please. Employers could also face retaliation, whistleblower, and wrongful termination claims. Typically, they're in response to workplace safety, working conditions, failure to provide adequate PPE, exercising leave rights related to COVID, as discussed before. Under OSHA, employees have a right to speak up about the hazards at the workplace without fear of retaliation. And again, as mentioned before, all the leaves related are all protected under the law. Next slide, please. Again, Greg touched on these points, and these were also addressed in the DIR guidance, but employers could also face wage and hour claims as well as failure to reimburse business expenses. So those are usually lumped together like plaintiff's counsel, especially for a lot of employees working from home currently. If there are a lot of non-exempt hourly employees, failure to provide rest breaks or meal breaks or overtime or reimburse business expenses, they could all be basis for liability. And actually in our next few slides, we'll discuss some telecommuting best policies to avoid these types of claims, as well as claims disputing pay practices relating to sanitation and hygiene protocols. Again, payment for such time is required if employees are subject to the employer's control during these times. And so payment would be made for all time spent. Next slide, please. We want to briefly touch upon best practices for telecommuting. I understand a lot of offices, including our own, have these practices, or a lot of employees are working from home for the foreseeable future. Regarding at-home workspaces, employees should designate a specific area as their workspace and ensure there are no hazards that could cause injury. We're also advising clients to ask the employees to document by photos submitted to them to HR to avoid potential any workplace injury claims that could arise while they work from home. We're also advising a lot of clients to have in place or update their non-discriminatory policies. If only certain employees are permitted to work from home, it should be based on legitimate business reasons, as well as accommodations made for them, which also includes equipment accommodations, whether it be a keyboard or other physical accommodations that they would need. We're also seeing data security issues. Employees should be encouraged not to work on their personal computers, and as well as send reminders about protecting company confidential and proprietary information while working from home. We see that this is a big important point to address. Next slide, please. Again, just best practices regarding hourly non-exempt employees: only work assigned schedules, no working off the clock, that should not be allowed. No overtime without prior authorization from a supervisor. Also, you should instruct such employees to not check emails, calls, or texts outside of regular work hours, or else they would need to be recorded and compensated. Timely take all rest and meal breaks away from the designated workspace area, as well as mandate accurate records of all time, as well as when meal breaks were taken, and submit it regularly, whether it be daily or weekly, to the employer. And we also recommend timekeeping acknowledgement and signatures, or even saying this timesheet is accurate under the penalty of perjury, etc. Just that kind of language, especially right now, will be helpful. And again, just you must pay for all time work, whether, again, we want to encourage no off the clock work and no overtime without prior authorization, but the employer needs to compensate the employees for all time work to avoid these kind of claims coming forward. Next slide, please.
And this is Spencer, just to add on to that point. It's also best not to have the employees just submit the same exact time every day. For example, started at 9, lunch at 1, back at 1:30, out at 5, or whatever it is, exactly the same every day. You want to have to the minute practices is best. You're allowed to do rounding as well, but we recommend to the minute punch outs.
Thanks, Spencer. And Greg touched on this point as well in the DIR guidance, but the California Labor Code requires employers to reimburse for all reasonable and necessary expenditures or losses incurred by the employee in the direct consequence of the discharge of his or her duties. So this does include reimbursement for equipment, supplies, materials, internet, Wi-Fi, as well as cell phone bills and data usage. So with unlimited plans, this requires reimbursement of a reasonable percentage of the employee's bill. So that's a friendly reminder for employers to track those expenses as well. Next slide, please.
A lot of clients are just doing a flat number, for example, $25, $50, $75, whatever it is. And then in the policy, you would have the ability for the employee to submit additional expenses if they think that it exceeds in any particular month.
We also want to shift focus to new California legislative updates in employment law. Next slide, please. First, we actually want to touch upon the Federal Families First Coronavirus Response Act. Again, this is a federal act and applies to private employers with fewer than 500 employees. And reasons that employees could take this leave is if the employee personally has COVID symptoms or had exposure to COVID, or the employee is caring for a person with COVID or COVID symptoms, or the employee needs to care for a child whose school or place of care is closed for COVID related reasons. Full-time employees are entitled to a maximum of 80 hours, which is 2 weeks paid leave. Part-time employees are entitled to pay for the number of hours that are normally scheduled to work over a 2-week period. If an employee is taking leave for his or her own illness, he should be paid at his regular rate. But if caring for a family member or a child due to school closure, then it would be 2/3 of their regular rate. And we will note that small businesses with fewer than 50 employees may qualify for an exemption from the requirement to provide the school closing leave if the leave requirements would jeopardize the viability of the business, and it's a growing concern. Also, we note that covered employers qualify for dollar reimbursement through tax credit for all qualifying wages paid under the FFCRA. Next slide, please. So that was the federal act. And so we want to discuss AB 1867, which is a California specific law, a supplemental paid sick leave law for COVID related reasons for certain employers not already covered by FFCRA. So this actually requires private employers that employ 500 or more employees in the United States to provide paid sick leave. It's effective from September 19th, 2020, when it was passed, to December 31st, or when the FFCRA expires, whichever is later. And full-time employees are entitled to the same 80 hours as FFCRA. And it could be taken for all the same reasons under FFCRA, except for the child school or place of care closure. And again, this leave is in addition to any other paid sick leave that the employee may be entitled to, whether by statute or by company PTO policy. Next slide, please. Also, SB 1383 significantly expands the California Family Rights Act beginning next year, January 1st of 2021. Just as a recap, CFRA leave may be used for an employee's own or for a family member's serious health condition, or for baby bonding due to the birth of a child or adoption of a child or placement of a foster child. So SB 1383 actually expands this coverage to all employers with 5 or more employees to provide 12 weeks of unpaid leave to eligible employees. Previously, the CFRA only applied to employers with 50 or more, and there was a requirement that employees work within 75 miles of the specific work site. But with this expansion, that requirement has been eliminated. It also expands the definition of family members under the CFRA to include also siblings, grandparents, grandchildren, and adult children. Previously, it only included the employee's parent, child, spouse, or domestic partner. So Potentially, this may allow an employee to take a combined total of 24 weeks of unpaid leave under the new CFRA and the current federal FMLA. For example, if an employee takes 12 weeks to care for a grandparent under the CFRA, the new CFRA, and then has to take care of a spouse, potentially they could take 2 separate leaves of 12 weeks of unpaid leave.
Just to add on to this, this is one of the most significant changes in California employment law in the last 20 years. This is, and they didn't really give employers a lot of time to get ready for this. So it's not like they put this out till next summer or even 2022. So all employers under 50 are going to need to look at their current handbook policies and make sure that it's updated in time and ready to go, and also train their managers, let them know that this is going to be in existence very soon. The full scope of the CFRA is a little bit outside the scope of today's presentation, but we can certainly happy to answer any questions you might have on that offline.
AB 685 is another COVID-19 law that was passed this year and effective on January 1st, 2021. So it requires actually very stringent reporting and notice requirements. So it requires employers to provide notices to various groups of employees within 1 business day after receiving a notice of a potential COVID-19 exposure. So as listed on the slide there, employers need to provide written notice to all employees who are at the worksite within the infectious period, as well as to employee representatives, including unions and sometimes attorneys who may represent these employees. Also, there needs to be a written notice provided regarding COVID-19 related benefits, such as workers' compensation, COVID leave, paid sick leave, as well as the company's anti-discrimination, anti-harassment, and anti-retaliation policies. And lastly, there must be written notice to employees regarding the company's disinfection protocols and safety plan to eliminate any further exposures per CDC guidelines. So, you know, especially the last requirement, this COVID specific rule will require employers to draft and implement a separate COVID-19 pandemic plan that addresses all exposures and identifies the manner in which the employer will correct these exposures and enforce these procedures and provide training, conduct inspections, and review its processes for effectiveness. And again, this kind of goes to all the resources that Greg pointed to during his presentation. But again, that's something that managers will need to implement as soon as possible. Next slide, please.
Really quickly, I'm going to jump in here to answer a question that someone had asked. As part of that plan, why not require antibody testing to determine immunity? And the reason why antibody tests are not sufficient is the EOC has held that even during this pandemic, requiring an antibody test to return to work violates the Americans with Disabilities Act. So it's flat out unlawful to require an antibody test, which is why even as onerous as a 14-day requirement is, that is the route and the method. It's because requiring that test can violate federal law.
Thank you, Greg. And to discuss kind of the smaller points of AB 685, so employers must also notify their local public health department, usually the county health department, within 48 hours if an outbreak occurs, which is defined as 3 lab confirmed cases at the worksite within 2 weeks. And also the act also gives Cal OSHA a lot more authority to either shut down businesses or give monetary citations for violations related to COVID as well. Next slide, please.
And just one thing I'll add on the Cal OSHA. We've had over the years lots of clients who don't have any notice at all that they've been being monitored by Cal OSHA. So oftentimes they will look at a particular industry or entity and be doing their background analysis without the employer having any knowledge, and then all of a sudden there's a citation issued. So just all the more reason to be proactive here.
And lastly, SB 1159, it creates a rebuttable presumption for workers' compensation benefits that an employee contracted COVID at work if the employee tests positive within 14 days after reporting to his workplace. And the act defines a specific place of employment as the building, store, facility, or agricultural field where an employee performs work at the employer's direction. And it actually does specifically exclude the employee's home or residence. And an outbreak is actually defined in 3 ways under this act. If the employer has 100 employees or fewer and 4 employees test positive for COVID-19, or if the employee has more than 100 employees, then if 4% of the employees test positive. And the third definition is if a specific place is ordered to close by a local or state health department due to a risk of infection in COVID. So those are the 3 definitions of outbreak under this specific act. And this presumption will exist from July 6, 2020, all the way to January 1st, 2023. And also there's a reporting requirement. If the employer knows or reasonably knows that an employee has tested positive, the employer is required to report to its workers' claims administrator in writing within 3 business days.
And just to add on to this, this was really controversial, and at a high level, we've talked about some of the claims that could be brought here against employers. Largely, the feeling is that, and the belief on the defense side is that almost all of those types of claims will be preempted by workers' compensation if brought by an employee, which is why SB 1159 was of a lot of concern to the business community in California. And there's a perception that this is going to result in just billions and billions of dollars of increased workers' compensation premiums. We'll see whether that's going to be true or not, but this is basically putting, from a public policy standpoint, this is basically putting the burden on the workers' compensation system to distribute out compensation for these kind of injuries by employees. The other thing, though, that we are seeing in recent weeks that is an interesting development, there have been some what are being referred to as take-home lawsuits. So the employee, but hypothetically, the employer is not properly protecting its workers, and therefore an employee contracts it at the workplace, takes it home, and one of their relatives or people they live with gets infected. And then that person brings a claim against the employer for negligence, and that person is not covered by workers' compensation. There's no preemption there. So these are brand new lawsuits. I've seen some of them in the last few weeks. I haven't dealt with them any personally, but we're just going to be watching that as the next area really that I think attorneys will be looking at and testing. Okay, so I'm going to jump in here. Thank you, Ashley and Greg. I'm just going to talk about the developments in independent contractor law in California. So a couple of years ago, with the Dynamex case and then the passage of AB 5, we had a major change in California law whereby we adopted what's known as the ABC test for independent contractor status. This test is set forth here on the screen, but it's a very stringent test. Basically isolates it down to these 3 factors as to whether somebody is a contractor or an employee. And all 3 factors would have to be shown. If any one factor is not satisfied here in the ABC test, then the worker is an employee, subject to some limited exceptions. And the hardest one that is typical for clients to meet is the factor B, outside the usual course, such that a contractor would typically be, in the examples given back in the Dynamex case, it's, you know, if you run an office building, the person who comes in and fixes your HVAC is a contractor and that kind of thing. They're not doing anything related to the business. So obviously quite different from how it had been done for decades in California. The ABC test and AB 5 was done, frankly, in a way that a lot of the California industries were very unhappy with and didn't feel like they were taking account in the process. And it was just a broad swath without looking at all these different industries. So as a result, and the impact on those industries. So as a result, the legislature decided to try to fix that situation and make it a little more lenient with this new law that I'm going to talk about. But basically, under AB5, there were these limited exceptions. There was professional services, things like lawyers, physicians, etc., subcontractors in construction. One of the key ones was the business-to-business contracting relationship. And they put forth a 12-factor test where all 12 factors had to be met in order to not just, that wouldn't alone get you to be able to say the person was a contractor. If you met all 12 factors of the AB5 business-to-business test, then you got to use the old test, which was called the Borello test, which was the more multi-factor test that we're all familiar with, similar to most states and federal law, IRS, etc. So you would have to hit these two tests. But the business-to-business test was really tough for people to meet because it had a factor in there that basically required the contractor to have not only their own, all these trappings of a standard business, but they had to have an active client list where they were actively providing the services to others, not theoretically. And so that was a really tough factor for a lot of the situations. And so they've loosened that up with the new law, AB 2257. Now it's a little bit less stringent. It's more like you can have, if you're open to being able to have those clients, you'll be able to potentially meet the business-to-business test. So they gave some flexibility there. And AB 2257 put together some other exemptions for various industries, which is, we could go into in a lot of detail in its own presentation, which we're not going to do today, but again, happy to talk about that offline. But one of them that I will highlight is the single engagement event. So this was creating a lot of problems for contractors who came in on a one-off basis for a particular event. And so they've loosened the criteria up a little bit for that as well. So there's that. But basically the takeaway on 2257 is they were trying to legislatively loosen up AB5 a little bit. I think they've done an okay job. We're still going to see a lot of litigation over this, and there's a lot that's not clear still, but at least they're making some effort to loosen it up under the versus AB5, which was quite rigid. Let's see. I think those are all the points I had on that. I'm going to turn it back to Ashley to touch on the final.
Thank you, Spencer. So these are just, I guess, more miscellaneous changes to employment laws this year, but AB 2017 kind of modifies the Kin Care law that we have in California. Currently, an employee can use up to half of their accrued paid sick leave to care for a family member, and this just revises it so that there are no designation errors, and the employee has a right to designate sick leave as kin care for specific days, and it's not just automatically half days, and they would unintentionally draw it. Next slide, please. Again, it's just smaller changes to employment laws, but AB 1947 extends the time to 1 year from 6 months for an individual to file a claim with the DLSC, which is the California Division of Labor Standards and Enforcement. Again, so this might be cause for concern, especially for claims of discrimination or retaliation in the COVID world that we live in right now. And also SB 973 requires a private employer that has 100 or more employees and who is already currently required to file an EEO-1 under federal law. They also need to submit pay data report to California Department of Fair Employment and Housing before March 31st, 2021. And these are the list of various COVID-related resources that Greg and I touched upon as well.
Right, and for anybody who needs this presentation or this list afterwards, just let us know and we can get you a copy. And all these links, right? Sorry. Okay, that's our last slide. I don't know if we have any open questions. I don't think so from looking at the Q&A. Okay. Well, that's all we have for today. Appreciate everybody attending. Feel free to reach out to any of the three of us if you have any questions. Happy to talk further. And
Okay, great. Thank you so much, everyone. I hope everybody enjoyed it. I will be sending a follow-up email along with the recording. And then the presentation, I think you said we could share that. So if so, I will be doing that. And I hope everyone has a great rest of the day. Thank you.
thanks so much.